everyone, welcome back to the channel. My name is Varun and I'm a legal intern at LEXIS and Company for the month of July. Today we are going to discuss about the topic anticipatory bail. Bail is cash or some type of property that is kept or vowed to a court to get the delivery from prison of a speculate who has been captured with the agreement that the presumed will return for the preliminary and required court appearances. On the off chance that the suspect does not get back to court, the bail is relinquished, and the suspect may potentially be raised on charges of the wrongdoing of inability to show up. Under the CRPC, there is two sort of bails: regular bail, section 436, and anticipatory bail, section 438. Section 33 of the CRPC depends on the guideline of bail and no jail. In case of Balchan Jain for the state of MP, the court has defined anticipatory bail as bail in anticipation of arrest. Anticipatory bail is a direction to release a person on bail issued even before the person is arrested. An explanation of anticipatory bail is given by the Supreme Court in the case of Gurbaksh Singh Sibia versus the State of Punjab that under subsection 1 of section 438 of the Code, the court must be satisfied that the applicant invoking the provision has reason to believe that he is likely to be arrested for a non-bailable offence, and that belief must be founded on a reasonable grounds. Mere fear is not belief, for which reason it is not enough for the applicant to show that he has some sort of vague apprehension that someone is going to make an accusation against him in pursuance of which he may be arrested. A person can apply for anticipatory bail even after the FIR is filed, but not if the person has been arrested already. Now I'm going to talk about object of granting anticipatory bail. Right to life and personal liberty is an important right granted to all the citizens under Article 21 of the Indian Constitution, and it is considered as one of the precious rights. Under Indian criminal law, there is a provision for anticipatory bail under Section 438 of the Criminal Procedure Code 1973. The Law Commission of India, in its 41st report dated September 24, 1969, pointed out that necessity of introducing a provision in the Code of Criminal Procedure enabling the High Court and the Court of Sessions to grant anticipatory bail. This provision allows a person to seek bail in anticipation of an arrest on accusation of having committed a non-bailable offence. The very basic purpose of insertion of this provision was that no person should be confined in any way until and unless held guilty. Provision relating to anticipatory bail under Criminal Code of Procedure. Where any person has reason to believe that he may be arrested on accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Session for a direction under this section that in the event of such arrest he shall be released on bail, and the court shall provide him anticipatory bail after taking into consideration the following factors, namely: number 1, the nature and gravity of the accusation; number 2, the antecedents of the applicant, including the fact as to whether he has previously undergone imprisonment on conviction by a court in respect to, of any cognizable offence; number 3, the possibility of the applicant to flee from justice; number 4, where the accusation has been made with the object of injuring or humiliating the applicant by having him so arrested. Either reject the application forthwith or issue an interim order for the grant of anticipatory bail. Where the High Court or Court of Session grants interim bail to the applicant, then the court forthwith a show cause notice attested with a copy of such order served to the public prosecutor and the superintendent of police, with a view to give the public prosecutor a reasonable opportunity of being heard when the application shall be finally heard by the court. The presence of the applicant seeking anticipatory bail shall be obligatory at the time of final hearing of the application and passing of final order by the court. If on an application made by the public prosecutor, the court considers such presence necessary in the interest of justice. Who is eligible to obtain anticipatory bail? When any person has a reason to believe that there is a chance to get him arrested on false or trump-up charges, or due to enmity with someone, or he fears that a false case is likely to be built up against him, he has the right to move the Court of Session or the High Court under Section 438 of the Code of Criminal Procedure for grant of bail in the event of his arrest, and the court may, if it thinks fit, direct that in the event of such arrest he shall be released on bail. Now I am going to talk about conditions for obtaining the anticipatory bail. The High Court or the Court of Session may include such conditions in the light of the facts of the particular case, including a condition that the person shall make himself available for interrogation by the police officer as and when required; a condition that the person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer; a condition that the person shall not leave India without the previous permission of the court. Supreme Court, while dealing the case of Siddharam Satlingappa, held certain conditions imposed by High Court to be not required and contrary to provisions of anticipatory bail. Now we'll talk about cancellation. An accused is free on bail as long as the same is not cancelled. The High Court or Court of Session may directly that any person who has been released on bail to be arrested and commit him to custody on an application moved by the complainant or the prosecution. What is the procedure for getting an anticipatory bail? For getting the anticipatory bail, the person may approach the High Court or the Sessions Court. As soon as the person apprehends, then that they may be arrested under section 406, 434 or under section 498A, they should consult a good lawyer for grant of an anticipatory bail. The lawyer will then file a wakalatnama in the appropriate district court with the required anticipatory bail petition. Then there will be a hearing scheduled by the court for the petition. Many a times it happens that the district and session court denies the anticipatory bail. Then the person must and shall appeal in the High Court, and the High Court generally grants the anticipatory bail. After the bail it is granted, there are few formalities that have to be followed before the person is finally out on bail. The court has the power to put some conditions and restrictions as discussed above. For conclusion, I'd like to say anticipatory bail was introduced in the court to prevent violation of personal liberty of a person. Now it has become a tool which is exercised by the people to escape from the criminal liability. That is why utmost care should be exercised by the courts while granting it, so as to prevent the abuse of this special privilege. The Honorable Supreme Court of India has emphasized on this point through certain judgments. Anticipatory bail is a device to secure the individual's liberty. It is neither a passport to the commission of crimes nor a shield against any kind of accusation. So it should be granted only to the people who actually deserve it. That's it for today's video. Thank you for watching. If you guys have any question regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.